few things what I have done so far in last 12 years. And this is a very interesting topic, intellectual properties, talking about the intellectual properties, talking about especially the patents. This is really important thing from IIC perspective also, because in quarter one, quarter two, both the quarters, this is a very prominent and very important topic. And I am really thankful to all of you. So without wasting any time, let us start now. And
Mahip ji, just
the
as
session.
formal part of the event, just I would start with welcoming you and other participants who have came here online and also watching directly, which have joined directly on our Google Meet and also through our this live event which has been shared on this
Right.
uh, YouTube. And let me start with introducing you with our audience. And at this point, I would highlight that Mr. Mahip Singh ji have more than 11 years of experience. Currently, he is head innovation hub at Dr. APJ Abdul Kalam Technical University, Lucknow. And previously, he has been coordinator Newgen IEDC ITS Engineering College, Department of Science and Technology, Government of India. And he was also assistant professor in mechanical engineering at the same institute. And previous to that, he has been director Navrachna Foundation at ITS Engineering College. And he has also worked as assistant professor and in charge innovation cell in Skyline Institute of Engineering and Technology. I think list is wide. I would means for the benefit of the our time and participants, just I would stop here. But I would say that he has it indicates that he has vast experience in the same field, and he is the able person and most suitable person for this event. He has also published some patents. Also, he has a long list of projects under his credentials, and he has taken many training projects, academic projects. So, I think, if you want to start with brief introduction of yourself, in which something you specifically you want to highlight, that would be great. And once again, I welcome you, and please, now
So
the
nice
stage
of you,
is
sir.
yours.
So nice of you. It was really very nice introduction of mine, and it's not about me, sir. It's about all of you who all of I mean your team is organizing this beautiful event, and you deserve to be appreciated, sir. Thank you very much, and I am really thankful for giving this chance to me to explain these things. And today we will be explaining about a lot of things. I will be discussing, I will be talking about a lot of things. I mean, whatever I have done so far in the field of IP and patents, especially. And I think I will be talking more about my experiences in the patents rather than speaking about the legal aspects of the patent and other things. I'm really sorry. So, because those things are available on the internet and anyone can see easily. So, I will be talking about those complications while filing any patent and how the patentability in any project can be put, and more about those things, especially. So, why this patent is important for all of you? I think students, most of the students has been joined so far, and intentionally I have blurred my background because shifting work is in process in my home. We have to shift from this NCR region to Lucknow, and today वो truck पे सब लद रहा है सामान, so background बड़ा बुरा सा है. Right, sir. So, why this patent is important for us? Let us understand by taking a simple example. Suppose one of our incubator student has started his or her own venture, and has started to make the products. And there is a fair possibility that this project has been stolen by any other. मुझे पसंद आया project and I took that project, and by making very slight change into this project, I making started the production. And there is also a fair possibility that by putting some permutation combination in the cost, in the efficiency of that product, ये fair possibility है कि मैं उससे बढ़िया काम कर ले जाऊं. So how to stop such type of stealing and such type of illegality? The patent has been introduced. So what the wrong that Incubity has done? The wrong thing was that he didn't apply for any patent. So coming on the point, this is the basic application of the patent to avoid piracy. So talking about the intellectual properties, थोड़ी देर मैं इनके legality पे बात करूंगा. इसके बाद मैं आ जाऊंगा कि क्या complications होते हैं कोई पेटेंट अप्लाई करने में और किस तरह से हम पेटेंट को अप्लाई कर सकते हैं. And I would be catering the students only. I would be catering those guys who are from technical background से सारे ही हैं, but I would be especially catering the students and would be motivating them to apply the patent, and would be talking about the complications of the patent, right? So intellectual property, right? So इनको हम तीन पार्ट में कर सकते हैं. So I mean, the definition of the intellectual property is anything which has been created by your mind, which is not tangible. And it can be anything. It can be any art, it can be any work designed, it can be any symbol, name, etc. So these properties can be called intellectual properties, and it is categorized into three different parts. First is the patent, second is the trademark, and third is the copyright. So trademark and copyrights comes into action after establishing your own venture, but primarily the patent is the most important thing, which is filed before starting anything, because copyright and trademark are more concerned about the business perspective, right? So okay, this is the this is the legal framework and administration of the IP. The Patent Act 1970 में बना था. Then patent rule was formed in 2003, and in the same way the Design Act was formed in 2000 and Design Rule in 2001. The trademark in 1999, trademark rule 2002, graphical indicators, geographical indicators 1999, and rule in 2002, and the copyright 1957. This is not at all important for anyone. इस स्टेज पे बिल्कुल important नहीं है. So this is a very important statistics for all of us. Why the China is leading in the field of innovation, in the field of patents also, because he has lot of innovative things to do, and he has been doing these things from last 20 years. So I have the data till 2020 itself. इसके पास जितने patents थे, that was more than almost 3 times of the US, जो कि second leading country है in the field of patents. So चाइना में ये सब चीजें बहुत ज्यादा होती हैं. चाइना को मैं इस मामले में बहुत अच्छा मानता हूं कि कम से कम we should have the thinking like Chinese in the field of innovation, because they search the shortest way to create any product and the most economical way to create any product. आज आपके पास अगर यूएस ने कोई मोबाइल लॉन्च किया है, चाइना उस आईफोन या एप्पल को वो उसके 1/4 कॉस्ट में लॉन्च करता है. How it becomes possible? It becomes possible only the जुगाड़ टेक्नोलॉजी and other things they have developed, and उनका हर एक चीज पे पेटेंट होता है. और पेटेंट सिर्फ इसलिए नहीं इंपॉर्टेंट है टू स्टॉप द पायरेसी, टू स्टॉप द मेकिंग प्रोडक्शन, इलीगल प्रोडक्शन. दिस इज आल्सो इंपॉर्टेंट फ्रॉम रॉयल्टी पर्सपेक्टिव, because this is valid for 20 years, and till 20 years if anyone has to create the same product like you have created, he or she has to give the royalty for 20 years. After 20 years the scene becomes quite different. उसके बारे में बाद में बात करेंगे. And our India comes on number 7. हमारे पास सिर्फ 56,771 पेटेंट्स टिल 2020 थे. I mean टिल 2020 नहीं बल्कि 2020 में हम इतने पेटेंट्स फाइल करते थे, एंड वी हैड फेयर रीजंस टू फाइल, आई मीन लेस नंबर ऑफ पेटेंट्स, बिकॉज पेटेंट फाइल करना तब के टाइम पे इट वाज क्वाइट एक्सपेंसिव दैट टाइम, बट न्यू पेटेंट रूल्स के अकॉर्डिंग ये अब जो है 1/4 1/5 कॉस्ट पे आ गया है. While filing any patent, जो चार्ज होता था it was around 8,000 rupees, but nowadays it has reduced to just 1,600 rupees. So जैसा मैंने बोला, we had fair reasons of not filing the patent that time, but nowadays because cost has been reduced so far, so अब hopefully हम patents के फील्ड में आगे बढ़ेंगे बहुत जल्दी. So that was the one thing. Second thing कि हम innovation पे थोड़ा promote कम करते थे. I mean reasons are so many, लेकिन innovation पे हमारा कम focus होता था. That was the another reason. So hopefully हम जल्दी अपनी ranking सुधारेंगे इसमें. So China is on number 1 and India is on number 7 till 2020. 2021 तक भी वो 7th number पे था. 22 का डेटा भी हमारे पास नहीं है. Coming on the core part, that is patent, right? So कुछ चीजें जो पेटेंट के बारे में है. So the patent is used to prevent an invention from being created, sold, or used to another party without a permission. Once you have a patent with your name, and if you have patent with your name and I have to make the similar product like your product, so I first of all I need to take permission from you. That permission may be carrying any term in between the party and the inventor. So कुछ भी हो सकता है, रॉयल्टी कितने परसेंट पे भी हो सकती है, anything can be in between. So patent are the most common type of intellectual property right that comes to the people's mind when they think of the intellectual property right protection. So this is very important thing. I have already told that I would be talking about the students only, and being students, this is the very important thing. Patent is the very important thing. So thinking about any idea, thinking about any, I mean, talking about any idea, thinking about any idea, the first thing should come in your mind should be the patent. कि हम अगर हमारे पास ये आइडिया है तो इस आइडिया के बेसिस पे we can make the product, and by making the product how can go for the patent. So that is one thing. अभी मैं उसके बारे में आगे बात करूंगा. A patent owner has every right to commercialize his patent, including buying, selling, patent of the getting a license to the inventor to any third party under the mutually agreed terms. And this is a very important and having a lot of financials transfer in between. So now we are talking about the technology transfer. So once we have developed our product, our patented and tested product for the market, and if we know that this product is having a huge demand in the market, we can go for the technology transfer also, because a lot of companies are there this time who are willing to purchase such type of technologies created by the young minds. So बहुत बड़ा financial involved है इसमें technology transfer में. So this is the another thing. So हमने 3 चीजों के बारे में बात की. We talked about the production of our product. First thing, जिसको कोई copy नहीं कर सकता. Third, we talked about the commercialization. Third thing, we talked about the technology transfer, right? Okay, few things are there. I discussed about the patent, trademark and copyright. So हम briefly इसके बारे में discuss करेंगे because we have limited time of 1 hour only. So trademark के बारे में discuss करेंगे. Trademark, this is a sign that allows customers to identify the particular goods service of the company. हम इसके बारे में भी discuss करते हैं बाद में. Some examples including McDonald's, Golden Ark, the Facebook logo on it. So trademark is something which is used for the trading. A particular symbol which is used for the trading is called the trademark. I mean, let it be very clear. There is a big difference into trademark and copyright. So trademark can be anything. Trademark can be any symbol. Trademark, I mean, can be any word by the people be any, like Coca-Cola. Coca-Cola has its trademark on designing of the bottle. So अभी इसके बारे में आगे हम बात करते हैं. Trademark come from the text, phrase, symbol, sound, smell, color, scheme, unlike the patent, right? So पहले एक बार मैं तीनों के बारे में बात कर लूं. And this trademark is valid for the 10 years. It can be anything. It can be any symbol. So trademark, like if I talk about the logo, like I'm an innovation hub, and if I'm trying to create my own logo of innovation hub, I should go for the trademark registration. So trademark registration का एक process होता है जिसके तहत कि the mark which I am carrying now can't be carried by anyone. तो ये हमें ये right देता है कि we can use this mark and nobody else can use this mark without my permission. Like IIC team is using the IIC symbol, and this IIC symbol is a trademark of IIC, right? And our IET logo is also the trademark of IET. So बिना IET के permission को उसको कोई use नहीं कर सकता. So that is the beauty of the trademark. But अच्छा, okay. So trademark is valid for the 10 years, and it can be the word including business name. It can be the brand, like phrase and slogans, brand identity, logos and symbols, sound including advertise. Then comes the copyright. Copyright does not protect the idea. This should be the very clear. Copyright का मतलब ये नहीं हो गया कि आप idea को protect कर ले गए. Instead, it only covers the tangible form and original work example, like the music, architectural drawing, or the software codes, right? So idea, I mean, for the trademark means, I mean, so far there are more than 45 trademarks. अब अगर मैं बात करूं, sorry, copyrights, more than 45 copyrights are there. Type of copyrights are there. So if I talk कि किसी एक particular चीज, I mean, music can be created by the anyone, but a particular type of music can be created by a person who has trademark on that music, right? अभी मैं example देता हूं आपको. Copyright is valid for 60 years, and this is the wrong information. This is valid for 70 years. मैंने गलती से लिख दिया है. And it can be anything: literary work, dynamic word, musical word, artistic, cinematography, and sound recording. So let us having a very good example, and before having the example, we should understand the difference between the copyright and trademark. So if we get anywhere this symbol TM, it means trademark. Trademark can be symbolized by TM, R, small r, or anything. And copyright is only symbolized with C under circle. हमने बहुत जगह देखा होगा. Let us understand by a very, very good example. This is the symbol of Harley Davidson. Harley Davidson has all three things: patent, trademark, and copyrights. कैसे? अब हम समझते हैं. So Harley Davidson is having a lot of patents on the technology. So utility patent it has. It is. I mean, Harley Davidson is having a patent on the suspension system. While the bike is standing on the stands, it seems to be very. It seems to have a very low height. Anyone can ride it while it is standing. Why? Because it was invented by the Harley Davidson team, air suspension, which is not active when the bike is in switch off mode. जब bike on mode में होता है, then only the air suspension comes in action. While driving this bike, you will feel that this is slightly elevating, right? So it was the technology which was invented in 2000. I'm sorry, in 98 or so. ये वाली technology जो थी, then this technology was very famous and it was used in most of the buses, low floor buses. अगर आपने अगर ध्यान दिया होगा तो low floor buses जब खड़ी रहती है कहीं पे तो उनका फ्लोर बहुत नीचे रहता है. When they start moving, वो धीरे धीरे करके उनकी हाइट थोड़ी सी, I mean सीलिंग हाइट नहीं, उनकी फ्लोर हाइट धीरे धीरे करके बढ़ती चली जाती है, right? So this is possible only because of the air suspension inside the buses, and that suspension was invented by the Harley Davidson first of all for their bikes. So this is the example of the patent. Automatic suspension system is the example of the patent developed by Harley Davidson for their bike. Next, coming on the trademark and logo. This is the very special logo of Harley Davidson. It's logo of the Harley Davidson. We can't use it without their permission. Third thing, copyright and sometimes trademark also. Exhaust sound. Harley Davidson is having a special type of sound. तो वो उस साउंड की वजह से ही अगर आपके आसपास हार्ले डेविडसन कहीं से मूव कर रही है, कहीं से जा रही होते हुए, तो हमें पता चल जाता दूर से ही कि हार्ले डेविडसन की आवाज है. एंड हाउ वी कम टू नो दिस? बिकॉज ऑफ द साउंड ओनली. इट क्रिएट्स वेरी स्पेशल साउंड एंड इट इज हैविंग अ कॉपीराइट. एंड नाउअडेज एक जो इलेक्ट्रिक व्हीकल आ रहा है उसमें एक स्पेशल टाइप का इलेक्ट्रिक व्हीकल हार्ले डेविडसन का इलेक्ट्रिक सेगमेंट जो आ रहा है, बिकॉज ऑल ऑफ द ऑटोमोबाइल कंपनीज हैव स्टार्टेड मेकिंग देयर इलेक्ट्रिक सेगमेंट आल्सो. सो द इलेक्ट्रिक सेगमेंट ऑफ हार्ले डेविडसन हैज अ वेरी डिफरेंट साउंड. उन्होंने जबरदस्ती एक साउंड उसमें डाला हुआ है ताकि हमें फील ऐसा हो कि हाँ हम बाइक चला रहे हैं हार्ले टाइप की. सो दैट इज हैविंग अ ट्रेडमार्क, राइट? तो उन्होंने कॉपीराइट एंड ट्रेडमार्क दोनों कर रखा है. सो दिस इज द बेसिक डिफरेंस इन कॉपीराइट एंड ट्रेडमार्क. सो कमिंग ऑन नेक्स्ट पॉइंट, मैं थोड़ा जल्दी भी चल रहा हूँ क्योंकि टाइम भी बहुत तेजी से बढ़ रहा है. सो व्हाई अ पेटेंट फॉर एनी इन्वेंटर और स्टार्टअप इज वेरी इंपॉर्टेंट. सो फर्स्ट थिंग, इट गिव्स द रिकग्निशन फॉर द इन्वेंटर. अगर आपका प्रोडक्ट है and which is having a patent technology, then it is recognized in different way. Few days before, I purchased a bottle, and I purchased that bottle only because there was written it is having patent. पेटेंट किस नाम पे था कि बॉटल्स जो पानी निकलता है उस टेक्नोलॉजी पे उनका पेटेंट था. सो टेक्नोलॉजी थोड़ी अलग थी. जब आप बॉटल को नीचे करेंगे तो पानी नहीं गिरेगा, पर जब थोड़ा सा स्लाइड करेंगे, स्लाइटली उसको इंक्लाइन करेंगे, उसमें पानी निकलने लगेगा. सो इट वाज पेटेंटेड टेक्नोलॉजी. सो product having patent with its name are recognized in different way, right? So incentive to develop a commercial product. How? अगर हमें प्रोडक्ट आपका शुरू करना है और आपका पेटेंट उस नाम पे है तो हमें आपको रॉयल्टी देनी पड़ेगी, हमें आपको इंसेंटिव देना पड़ेगा. So it has two different co-steps, which is license to existing company and start up a new company. Both things are there. Next, protection against the imitators. जैसे मैंने सबसे पहले बोला कि I can make the same product if you haven't patented your product so far, because you don't have any right to stop me of making this product. But if you have a patent, utility patent, a technology patent, a design patent, any type of patent you're having, then only you can stop me of imitation. Right? So this is the very important thing while starting your own venture, because again I'm saying I'm discussing all these things from a startup perspective only. So before going for any venture, before going for any innovation driven enterprise, दो type की enterprise होती है. One is small, medium and conventional enterprise. Another is innovation driven enterprise. So here we are not talking about the conventional enterprises, because conventional enterprises में आपका जो ग्राफ होता है revenue generation का, that is either linear or less than the linear. टाइम के साथ साथ उसका revenue generation इतना ज्यादा नहीं होता, थोड़ा कम रहता है. So here we will be discussing about the innovation driven enterprises only, because innovation driven enterprises, there are fair possibility of fund burn for some time, for few years, while our product or while our business comes to the break-even point. But once it has reached the break-even point, so there is an exponential growth, exponential revenue generation inside. So इसीलिए innovation driven enterprise पे हम सबका focus बहुत ज़्यादा है. Not only the innovation hub is focusing on this part, but entire government, entire India, everyone is approaching for this type of innovations. बड़े सारे उसके reasons हैं, right? So before starting any innovation driven enterprise, we should go for the patent first of all, कि हमें सबसे पहले अपने उस आइडिया को, जो जिस आइडिया की मार्केट में डिमांड है, उसको हम पायरेसी होने से, उसको हम इमिटेशन होने से रोकेंगे. So from that perspective we should go for the patent. और आज के जमाने में इतना महंगा अफेयर नहीं है पेटेंट. पेटेंट आजकल जमाने में बहुत सस्ता हो गया है. सो इनिशियली माय लॉट ऑफ पेटेंट्स, आई इन्वेस्टेड मोर देन $1 lakh फॉर अ पेटेंट. लेकिन अब ये काफी सस्ता हो गया. विद इन 50,000 40,000 यू कैन गो अप टू द लास्ट लेवल ऑफ द पेटेंट, राइट, टिल लास्ट लेवल ऑफ द पेटेंट. सो 50,000 में आपको पूरा पेटेंट मिल जाएगा. यू कैन हैव अ ग्रांट ऑफ पेटेंट, right? So what can be patented and what can't be patented, it's very important to understand. So for any patent, first of all, keep in mind that idea can't be patented. पहली चीज है. So idea आप सिर्फ सोच सकते हैं, but idea को आप express कैसे करेंगे, कि मेरा ये idea, इसको आप express कैसे. But it is kept in the case, you can come anytime yourself into wheelchairs also. So this is very important for hospital perspective. And that time when the COVID came in action first time in 2018-19, so it was very important at that time, because it was having temperature sensing machine, it was having sanitizing system on the back side while it's free time. जब ये free होता था तो it used to sanitize the small room automatically. And it was also having the UV disinfectant system for the worker, for the और ऐसे करके इसमें बहुत सारी BLDC मोटर हमने लगाई थी. कन्वर्जेंट टेक्नोलॉजी इसमें था. इंटरैक्टिव डिस्प्ले इट वाज हैविंग, एंड CCTV रोल इट वाज हैविंग. सो लॉट ऑफ अदर थिंग्स इट वाज हैविंग. सो इसके बावजूद भी जब हमने इसको पेटेंट के लिए अप्लाई किया, वी केम टू नो दैट we couldn't qualify the non-obvious criteria, because whatever things we have put inside this robot was obvious. Obvious means if I am claiming that I am using BLDC motor with planetary gearbox system or any type of gearbox system, that was the combination of the existing technology. We haven't done anything new. That was the application only. If I'm saying that we are using such type of sensors to use the temperature of any person, that was also not any non-obvious thing. Display was not, मतलब इसमें था जो कि obvious ना हो. ठीक, तो उस क्राइटेरिया के तहत ये पेटेंट से वापस आ गया. So what I'm trying to make you understand why this was rejected. And once your patent is rejected, तो आपको थोड़ा सा अपडेटर होते हो, आप demotivate होते हो. So to avoid these circumstances, one should go with the all fulfilled criteria. तो मैं इसलिए आपको बता रहा हूं. So ये हमारा पहले का प्रोजेक्ट था. सो हमें इतना इसके बारे में इंफॉर्मेशन भी नहीं थी. मतलब क्या हम ऐसा डाल दें इसमें कि ये नॉन ऑब्वियस हो जाए. सो आई एम टॉकिंग समथिंग डिफरेंट. आई मेड अ प्रोडक्ट व्हिच वाज वेरी यूजफुल फॉर द हॉस्पिटल पर्सपेक्टिव, बट इट वाज नॉट पेटेंटेड टेक्नोलॉजी. सो व्हाई वी couldn't start production, although we had demand of 5-6 different hospitals. 2-3 तो हमारे यही ग्रेटर नोएडा के थे. We couldn't start this because we knew that once we have made this and we have delivered to any person, he can make the replica of this. How we will stop the imitation? वही वाला पिछला वाला क्राइटेरिया आ गया कि हम रोकेंगे कैसे इसको बनाने से. हम नहीं रोक सकते. So हम इतनी मेहनत भी कर रहे हैं. We should establish a venture for this to make this product, and after this कि क्या होगा कि हम इसको बनने से रोक नहीं पा रहे हैं, तो इसका फायदा नहीं है स्टार्ट करने का इस पे वेंचर. So coming on the point, novelty, yes, it had novelty. Usefulness, yes, it has very useful. Novelty कैसी थी? Novelty ऐसी थी कि हमने बहुत सारी ऐसी चीजें लगाई थी, ऐसी चीजों का कॉम्बिनेशन लगाया था जो कि पहले नहीं था एग्जिस्टेंस में, right? Like convergent technology using pneumatic system, pneumatic control feedback system. That was the novelty of the project, right? And another thing, जो हमारा टेम्परेचर सेंसिंग था, वो टेम्परेचर सेंसिंग एक हमारे क्लाउड पे जाके स्टोर होता था ऑटोमेटिकली. दैट वाज द नोवेल्टी ऑफ द सिस्टम. एंड वी हैड अ मैग्नेटिक ब्रेकिंग सिस्टम इनटू दिस. सो वो भी नोवेल था. usefulness, I need not to tell about the usefulness, because it was very useful, not only for the hospitals, but for the other things, for the restaurants also, for the general purpose also. It was very useful. It was having a speed of 20 kilometer per hour, and it was having a lithium ferrophosphate battery set inside it, which was having around more than 4 hours of battery backup, full motion battery backup, right? But non-obvious criteria we couldn't qualify. That's why we couldn't get a patent on this. Then what we did, उसके बारे में बाद में बात करेंगे, हम अभी बताएंगे थोड़ी देर में. It can't be patent, keep in your mind. बहुत सारे लोग बोलते हैं कि आइडिया पेटेंट जैसा कुछ नहीं होता है. It doesn't exist even. आइडिया पेटेंट कुछ भी नहीं होता है. Only there is a product patent. I mean, based on your idea, if you're going to make any product, then it can be patented. Because product में हम देख सकते हैं कि ये तीनों चीजें, जो ऊपर की तीनों चीजें हैं, is it novel or not, it is useful or not, is it obvious or not. So idea can't be patented, only product can be patented, right? So ideas को हम बहुत सारे ले सकते हैं. Like if I say that in place of using the small fan, which is having a diameter around 1200 millimeters, I can make a big fan which is having diameter more than that, right? So idea कहाँ से? Idea ऐसे आया कि I'm sitting in a hall. I found that 10 fans are continuously being deployed in order to make the hall cool, right? Or normal. So आइडिया कहाँ से दिमाग में आया? आइडिया दिमाग में ऐसे आया, भाई हम क्यों नहीं कर सकते, अगर 10 फैंस हैं, so all 10 fans are creating different sound, and the combination of entire sound is ultimately decibels हमारा बढ़ा रहा है, हॉल का noise level हमारा बढ़ा रहा है, pollution बढ़ा रहा है. Another thing, from those 10 fans, obviously इनका maintenance भी ज़्यादा होगा. By every month एक ना एक फैन उसमें खराब ही होगा. So maintenance is one thing. Then pollution, noise pollution is another thing. Then power consumption, because एक fan का अगर on an average power consumption हम 10 watt का 100 watt का माने, so ultimately combined power consumption is not going to less than 1000 watts. So 1 kilowatt का power consumption है. In place of putting those 10 fans, why I can't put a single fan which is bigger in size, having low power consumption and low noise production, right? So it was invented. अगर आप लखनऊ रेलवे स्टेशन पे देखेंगे तो बड़े बड़े फैंस लगे हुए हैं. So very first time when I saw those fans, मुझे समझ में नहीं आया था कि ये हवा आ कहाँ से रही थी अच्छी. But coming on the next point, it was not patented technology because it was the replica of the existing small fans. It was novel because if someone said that I have used BLDC motor inside the fan,
रामू कहाँ जा रहे
in place of using existing motor, is there any turbulence? Right. So it was novel, it was useful also, but it was not non-obvious. It was very obvious that deploying any motor having a big size of blade will automatically give the same effect like a small fan. So उसपे हम patent नहीं ले सकते, right? And if you are having an idea of making such fan, so idea can't be patented until you convert to a product, और अगर product में convert कर दिया, so it should qualify these 3 criteria: novelness, usefulness, and non-obviousness, right? So law of the nature also can't be patented because law of the nature तो law ही है, उसको हम patent कर भी नहीं सकते. So these are the categories, 3 categories who can't be patented. अगर हम बोले कि gravity लगती है तो भाई लगती है, उसको तो न्यूटन भी नहीं कर पाए पेटेंट, तो हम क्या, आई मीन दैट कैन हैव अ डिफरेंट नेम हु हैज इन्वेंटेड दिस लॉ, बट उसका पेटेंट नहीं हो सकता बिकॉज दिस इज अ लॉ ऑफ द नेचर. वी डोंट हैव एनी कंट्रीब्यूशन टू मेक दिस थिंग हैपन, राइट? इट हैपेंस, इट ऑटोमेटिकली हैपेंस. So it can't be patented. Similarly, the scientific principles also can't be patented. If I say that F equals to ma, so mass तो force तो mass और acceleration के multiplication के बराबर ही होता है. So उसमें हम कुछ नहीं कर सकते. That is true. That is universal truth. That can be discovered only. That can't be patented. That can be discovered only. So all the laws of the nature and all the scientific principles can't be patented, right? So keep this in mind. अच्छा, इस एग्जाम्पल के बारे में बात कर चुके हम. Okay, so how we got patent on this part? मैं थोड़ा सा इसके बारे में बात करता हूँ कि पहले हमें पेटेंट नहीं मिला because it was not qualifying the criteria of non-obviousness, right? So second pandemic, I mean second जो लहर आई थी हमारी कोरोना की, उसमें क्या हुआ कि there was a huge deficiency of the oxygen everywhere, and we passed through a good crunch of oxygen, and oxygen के लिए बहुत मारा मारी थी शुरू में. सेकेंड वेव की बात कर रहा हूँ. So हमारे AKTU ने ऑक्सीजन हैकाथन भी ऑर्गेनाइज करवाया था. I was the jury member in that. So from that point a very good idea came to mind कि अगर ये रोबोट सर्व करने के साथ साथ ऑक्सीजन की मॉनिटरिंग भी स्टार्ट कर दे तो कैसा रहेगा. So that was the opportunity where our team focused, because oxygen hackathon was all about to save and to utilize the oxygen and how to stop the wastage of the oxygen. इसके बारे में सब कुछ था वो. So there were 5-6 points where oxygen was being wasted. So उसको हम कैसे रोक सकते हैं. तो एक पॉइंट ये भी था उसमें कि जब हम ऑक्सीजन को पेशेंट के पास रखते हैं तो पेशेंट पैनिक होकर ऑक्सीजन की क्वांटिटी को ज्यादा खोल देता है, एंड समटाइम्स जब वो सोता है तो सोते में उसका मास्क हट जाता है वगैरह वगैरह, बहुत सारी चीजें थी. So keeping those things into mind, we deployed a master circuit inside this robot who was able to control the oxygen parallelly for 7 different beds. वो कैसे कंट्रोल करता था, क्वांटिटी कितनी होनी है, and it indicates to the health worker if the mask was misplaced for the face, because misplacing the mask means wastage of the oxygen. So primarily we thought that we should stop the supply of the oxygen when the mask is misplaced. Then later on we thought कि नहीं ये थोड़ा सा dangerous भी हो सकता है. So in place of stopping the supply, we should indicate the health worker कि भाई मास्क हट गया, आप जाके लगा दो उसका. Or no one could control the supply of the oxygen without permission of this robot or without permission of the central room. So this entire information was given to the central or control room by this robot only, by observing the things. So that was the very unique thing what we put into this robot, and that was non-obvious. That was the only point where we got the patent on this entire robot, right? Although we could go for the design patent, because design patent is something very different from the utility patent. Here we are talking about the utility patent, and from your perspective, from student perspective, utility patent is very important, not design patent. Design patent आप किसी चीज का भी कर सकते हो. So any product you have designed, you can go for the design patent provided you have made its CAD model, जो कि हर एक चीज को डिफाइन करता हो. तो from 6 different angles you should shoot the photograph, and you should have all the dimensions of different parts, and you should apply for the design patent. उसका भी चार्ज यही है, 1600 रुपए ही है, सॉरी 4000 रुपीज है, राइट. सो डिजाइन पेटेंट के बारे में हम बात नहीं कर रहे. वी आर टॉकिंग अबाउट द यूटिलिटी पेटेंट, वी आर टॉकिंग अबाउट द टेक्नोलॉजी पेटेंट. सो इस तरह से हमने इस पे पेटेंट लिया था. देन आई एम टॉकिंग अबाउट द वैलिडिटी. यूटिलिटी पेटेंट्स आर वैलिड फॉर 20 years. आफ्टर 20 years you should go for another patent, or it is considered that if any idea is novel on this date, today, after 20 years it would be obsolete. Other ideas आ जाएंगे. So उसके बाद ये patent valid नहीं होता. But once you got the patent, you have to protect it. Patent का grant होना important नहीं है. Grant होना important ऐसे है, if you have to beautify your resume by adding this line that I have patent on this part, then it's important. Else, if you're going for making a product based on this patent, you have to protect it. You should protect it. So having a patent is one thing, and protecting the patent is another thing. सो फॉर प्रोटेक्शन ऑल्सो आपको सब्सक्रिप्शन या आपको पेटेंट लॉयर से कॉन्टेक्ट करना पड़ेगा, भाई हमें प्रोटेक्शन भी चाहिए इसका. सो कुछ वो चार्ज करते हैं कि भाई कोई कोई इसमें कॉपी तो नहीं कर रहा. प्रोटेक्शन इज नॉट अबाउट टू अवॉइडिंग द इमिटेशन. प्रोटेक्शन ऑल्सो ओपन्स सेवरल डोर ऑफ रेवेन्यू जनरेशन. हाउ? जैसे हमें पता चल गया कि हमारा माई प्रोडक्ट इज बीइंग प्रोड्यूस्ड इन सम कंपनी इलीगली, आई कैन क्लेम फाइनेंशियली कि आप हमारे प्रोडक्ट का इस तरह से इस्तेमाल करते हैं. आपने बहुत सारे न्यूज में देखा होगा कि उन्होंने इतने करोड़ रुपए, इतने मिलियन डॉलर का क्लेम कर दिया गूगल के ऊपर, इनके ऊपर, फेसबुक के ऊपर. सो ये सारी चीजें किस तरह से हो सकती हैं? सारी चीजें तभी हो सकती हैं जब आप अपने पेटेंट को प्रोटेक्ट कर रहे हो, जबकि आप जान रहे हो कि कौन कौन ये काम कर रहा है. प्रोटेक्शन मीन्स ये भी होता है. कमिंग ऑन द नेक्स्ट वैलिडिटी, डिजाइन पेटेंट इज वैलिड फॉर 14 years. Then plant patent is valid for 20 years. So I have couple of design patent also. I have more than so far I have more than 15 utility patent and 2 design patents. I'm sorry, मैं डिजाइन पेटेंट के कुछ एग्जांपल्स डालना भूल गया था क्योंकि वो पीपीटी जो कि AKTU में रखी थी वो मैं लाना भूल गया उसे. So design patent is valid for 14 years. Then plant patent is another thing. Plant patent means कोई भी चीज, कोई भी प्लांट जिसको हम अलग तरीके से क्रिएट करते हैं, ठीक है, वो चाहे हाइब्रिड तरीका हो चाहे कोई भी तरीका हो. सो इट्स ऑल अबाउट मेकिंग अ न्यू प्लांट व्हिच इज हैविंग डिफरेंट कैरेक्टरिस्टिक फ्रॉम द एग्जिस्टिंग वन. सो इसकी कुछ टर्म कंडीशंस होती हैं कि यू शुड हैव दिस प्लांट फॉर 1 year विद यू, इसकी फिजिबिलिटी देखने के लिए कि ये चलता है नहीं चलता है या कैसा इसका आउटपुट है. सो 1 year अगर आपने इसके साथ बिता लिया, देन ओनली यू कैन गो फॉर द प्लांट पेटेंट by claiming that this is something different. अगर हम फ्लावर्स की बात करें, so this is the combination of, जैसे गुलाब का हमने बहुत सारा गुलाब की बहुत सारी ब्रीड्स हमने देखी हैं, बट बाय डिफॉल्ट गुलाब तो गुलाबी कलर का ही होता था, लेकिन अभी अलग अलग कलर्स का कैसे आ गया? सो इट्स द कॉम्बिनेशन ऑफ डिफरेंट ब्रीडिंग सिस्टम ऑफ द प्लांट्स. सो आप उसको पेटेंट कर सकते हो प्रोवाइडेड इफ यू आर कैरिंग फॉर 1 year दिस प्लांट विद यू. सो दिस इज वैलिड फॉर 20 years अगेन. देन कॉपीराइट लाइफ टाइम के लिए वैलिड होती है. देन फॉर 70 years आफ्टर द डेथ ऑफ दैट पर्सन हु हैज अप्लाइड फॉर द कॉपीराइट, राइट. सो इफेक्टिवली अगर हम माने कि किसी की एज 70 years है, सो अनदर 70 years मींस दिस इज वैलिड फॉर 140 years कॉपीराइट. देन ट्रेडमार्क इज वैलिड अंटिल योर वेंचर इज ऑब्सोल्यूट, राइट. जब तक एग्जिस्टेंस है आपके वेंचर की तब तक ये ट्रेडमार्क वैलिड रहता है, राइट. देन क्विकली कमिंग ऑन द अदर पॉइंट्स, what are the part of the patent? That is the background of the invention, summary of the invention, figure of the description, detailed description, specification, and claims. Few things are very important in this. You must be knowing that this is the obvious things, abstract, background, summary of the invention, because अगर आपने काम किया है तो आप abstract तो लिखना जानते ही होंगे, like the paper we used to write the abstract. Then summary of the invention. Summary means why it is useful, not about the technology part, but why it is useful for a human being or for society. Then figure with brief description, as much as figure you can put in the patent part or while applying the patent, you have the more chance to get it filed successfully. Detailed description and specification always plays very important role while filing or drafting the patent. First thing, I would recommend that while before filing any patent, you should go for any patent authority, any patent attorney to file this patent, because they have the enough knowledge, they have the terms, those legal and technical terms, why to write the patent, why to draft the patent, they know it well, right. So go for any and if you are filing it your own, that's not a bad thing, but उसमें आपका टाइम बहुत ज्यादा लग जाता है, because that language, जिस लैंग्वेज में लोग लिखते हैं वो लैंग्वेज हमें सीखने में बहुत टाइम लगता है और उसमें ड्राफ्ट करने में बहुत टाइम लग जाता है. सो बहुत ज्यादा उनका चार्ज नहीं होता, 5-6 हज़ार रुपए चार्ज करते हैं वो. इसके अलावा द गवर्नमेंट फीस विच इज वर्थ 1,600 rupees, वो आप पे करके यू कैन गो फॉर इट. बट while drafting any patent, you should go for maximum number of pictures, maximum number of figures. right? And one of the very important thing, which is claim, right? Claim is very important because हम स्पेसिफिकेशन हम ड्राफ्ट में पूरा ध्यान देते हैं, बट हम एक्चुअली क्लेम क्या कर रहे हैं वो ज्यादा इंपॉर्टेंट है, बिकॉज पेटेंट ऑफिसर हमारे क्लेम को सबसे पहले पढ़ता है, right? So there are a couple type of claims. One is independent claim, one is dependent claim. So if I talk about the independent claim, this is a stand-alone claim. इसको हम stand-alone claim भी बोलते हैं, right? So there are three type of independent claims we can say, right? So इसके बारे में बहुत ज्यादा बात नहीं करेंगे तब तक जब तक कि क्लेम्स के बारे में तो एक अलग ही पूरा का पूरा हम लोग बातें कर सकते हैं जब आप इस पोजीशन में होंगे कि आपने कुछ पेटेंट्स फाइल कर लिए हैं और आपको और फाइल करना है. सो व्हाइल you will be interested to know more about the claims, तो इसके बारे में हम पूरा एक डिस्कशन बाद में रखेंगे. And the dependent claim is another type of the claim, right? वो dependent claim होता है. So एक छोटा सा एग्जांपल मैं लेता हूँ ऐसे ही, like if I'm talking about the rooftop of a home, of a house. So if I said that rooftop is made of vinyl sheet, right? So vinyl sheet का rooftop होना एक independent claim हो गया. Next, that rooftop which is made of vinyl sheet is having green color. Now that is dependent claim. That second claim is dependent on the first claim, right? Third claim, if I'm saying that this rooftop, along with this rooftop, there is another layer which is made of metal. Again, this is again independent claim. Dependent claim क्या है कि that metal is having a black color. So this can be called dependent claim again. So I think you are having brief information about the claims. हम आगे बढ़ते हैं, इस पे ज्यादा बात नहीं करते. टाइमलाइन बहुत इंपॉर्टेंट है पेटेंट फाइलिंग में. 18 months उसको पब्लिश होने में लगता है, एंड विद इन फ्यू वीक्स यू कैन गेट अ टेम्परेरी पेटेंट नंबर व्हाइल अप्लाइंग द पेटेंट. आज अगर आप पेटेंट अप्लाई करते हो तो विद इन वीक यू कैन गेट अ एप्लीकेशन नंबर. देन आफ्टर 18 months you would be able to go for the publication, right? So 18 month is the time criteria when you have not applied as an early publication. If you have applied as an early publication, then within a month you will get publication. All the information would be available on internet, right? And after publication, within 4 months you can go for the call for examination. That examination calls means the patent officer is invited by you to examine about all the claims what you have filed, right? So वहां पे decision होता है whether all the claims are right or not. If he is not satisfied, he then sends the queries, and this query is again drafted by the inventor. और वो क्वेरी का फिर रिक्वेस्ट फॉर एग्जामिनेशन होता है. देन क्वेरी का हम ड्राफ्ट फाइल करते हैं, राइट? जब ड्राफ्ट फाइल करके उनको भेजते हैं, एंड इफ ही इज सेटिस्फाइड, वेल एंड गुड, देन ही विद इन 6 months he gives a grant. And if he is not satisfied, then he calls you for the hearing. तो आपको हियरिंग में जाना पड़ता है. हियरिंग के थ्रू आपको आमने सामने बात होती है, भाई हम इस तरह से बोल रहे हैं और उसने बोला कि आप किस तरह से ऐसे बोल रहे हो, इस तरह से कैसे बोल रहे हो, और आपको वहां पे समझाना पड़ता है, राइट? सो हियरिंग के बाद कई बार वो पेटेंट को ग्रांट करता है या फिर नहीं ग्रांट करता है. दोनों चीजें होती हैं. एंड द फाइनेंशियल इन्वॉल्व इज वेरी सिंपल. 1600 is the charge by individual for applying the patent. Then if you go for early publication, then 4000 additional charge you need to give. Then request for examination के लिए 10,000 रुपए चार्ज होता है. Then FER फाइल करने के लिए 20,000 चार्ज होता है. First examination report. So ultimately कुल मिला के around 50,000 में you will be able to get a grant of a patent, right? Right. Utility, plant, and design patent. I have already talked about this. 3 type of patent. Utility type patent. What about we are talking? कि हम यूटिलिटी पेटेंट की बात करते हैं, बीइंग स्टूडेंट्स, देन plant patent. So how plants are being created, how different characteristics plant are being created, and design patent. Design patent is the most easiest way to get any patent, design patent, और जल्दी हो भी जाता है. So how to make a product and how to make a product or project novel. I would like to take an example, which is anti-milk spilling unit. What we, I mean, I and my team has made. मैं इसको quickly खत्म करता हूँ. So this device was earlier available by the Chinese and हमारे इंडिया में भी चाइना से इंपोर्ट होकर डिवाइस आती थी, which indicates that whenever the milk is about to, yeah, yeah. सर थैंक यू वेरी मच. 5 मिनट आर मोर देन सफिशिएंट. मैं तो उससे पहले ही खत्म करने के मूड में था. सर सर क्विकली क्विकली क्विकली, ये हम लास्ट पे चल रहे हैं ऑलमोस्ट. So continuing this part, this machine was already available by the China in the market, but it was indicative only. Whenever the milk was about to boil, it indicates. So हरी में हमें जाना पड़ता था. We need to switch off the गैस और उस तरह से हमें बंद करना पड़ता था. बट इट हैज अ वेरी लेस टाइम इन बिटवीन द इंडिकेटिंग एंड इन बिटवीन द क्लोजिंग. सो उसमें कई बार हम इसको रोक नहीं पाते थे. सो वी एंड आवर टीम, मी एंड आवर टीम had a discussion why not to having a preventive machine along with this. So हमने एक टॉप यूनिट बनाया, एक कंट्रोल यूनिट बनाया, और दोनों आपस में कम्युनिकेट करते थे वायरलेसली, और कम्युनिकेशन के थ्रू जैसे दूध बॉयल होता था, हैविंग कपल ऑफ सेफ्टी यूनिट्स, वो ऑलरेडी बंद कर देता था दूध को. तो ये एक बहुत पॉपुलर प्रोडक्ट था हमारा, राइट. सो मैं ये क्यों बता रहा हूँ, ये मैं इसलिए बता रहा हूँ कि हमने इसमें नोवेल्टी किस तरह से रखा. हमने नोवेल्टी इस तरह से रखा और इसमें हमें पेटेंट मिला, राइट. सो अनदर पार्ट वाज स्मार्ट डाउन रॉड. स्मार्ट डाउन रॉड is a smart way to prevent the hanging from the fans, because 1.6 more than 1.6 lakh of people hang and commit suicide every year worldwide. उसमें से 60% हमारे इंडिया के होते हैं. So this is the biggest pain point of the society. To avoid this, we made a smart down rod, which is having a smart latch mechanism. Smart latch mechanism is not having any type of external power supply needed. So it is completely mechanical, and whenever we push the whenever more than 40 kg of weight is being hanged on this fan, it automatically comes down slowly, gradually, and it is not having any abrupt part where we can tight the rope or anything. जैसे ही हमने कुछ भी इस पे डाला, ये धीरे से नीचे आ जाता है 40 kg से ऊपर. Apart from this, this is a very useful for cleaning purpose, for repairing purpose, because once we push this entire system towards upward for 2 centimeters, it automatically comes down, and by same way it comes up, it goes up. And latch mechanism, smart latch mechanism, does all these things, right? So not talking more about these things, few important things were there, but I would share these things. Why to draft the patents? We had few questions and answers to be done by the inventor. ये कुछ चीजें थी जिनका आंसर हमें खुद लिखना पड़ता है while drafting any patent. And in the continuation we had few other things also. So मैं इस चीज को, अगर किसी को जरूरत हुई तो मैं इस चीज को प्रोवाइड कर दूंगा बाद में, बिकॉज कैसे मैं ड्राफ्ट करना है पेटेंट को, ये सारी चीजें इसमें लिखी हुई है क्वेश्चन के फॉर्म में. So what things we need to explain while drafting any patent is written. So this draft was made by this idea was prepared by Innovel IP, which is based on Noida, right? So thank you very
Sir,
much.
please share this PPT, sir.
Sure. I'll share.
Okay, sir. Thank you.
So if any question anyone is having, please let me know. मैं आता हूँ, एक सेकेंड। राइट। ड्रोन, सॉरी, आपने पूछा कि डिफेंस पर्पस से, फिर प्लीज एक बार फिर से आप कंटिन्यू कीजिए। Right. So, I mean, we and our team was debated on the point that how we will ensure its noble use. Because see, drone technology and controlling the drone is itself a big task for the government these days. A lot of rules and regulations are being created every day. बहुत सारी meetings हो रही हैं इसके regarding. So to control the drone itself, and if we are having something which is killer machine inside the drone, how we will ensure its novel use? That was the one part. उसके regarding हमारे पास 12 questions आए थे और हमारे पास एक satisfactory answer नहीं था. But it doesn't mean that AK-47 can't be patented. उस पे patent है. But so far we are having a good policy for the drone itself. To control the drone, then only we can go for any application of the drone, because this is the drone application, and both the applications, I mean, controlling the drone is itself a big task for the government, and then having a bullet and uska right usage, वो एक other difficult part है, right? So इन दोनों चीजों का आंसर हमारे पास नहीं था.
And what things should be taken care, where you have also defined what are the types of patents also, and type of claims. I think this topic itself needs a physical workshop, and we will in future plan a workshop where physically you can come and other interested students can come and join us, and that would be very great. If you have in future, you can assure us that you can provide some time for that. That would be very
Absolutely right, sir. It would be even privilege for me to join all of you, offline at your place or at any place. Because I requested to Mr. Sandeep to make it offline, but by some unavoidable circumstances, he couldn't. So मैंने बोला ठीक है इसको, because 1 hour is not sufficient to tell all about the patent and their nitty-gritties.
Yes.
So
Yes.
You are very right. So if given a chance in future, certainly I'd come and discuss about these things.
If anyone from students and participants who are live on this Google Meet, they can also ask questions.
Sure. Any question from any
yes,
side?
Raj, yes, you can ask. Yes.
Sir, good afternoon, sir. So you showed an example that your robot for the hospitality was defeated because you cannot use any new technologies in it. So, sir, if we design a robot which is using the existing technologies like existing motors and batteries, everything, but the gear mechanism inside it and everything is a new type. So, in that case, can we patent it or not?
No. Yashraj, you can't patent it. You can't go for the patent using the same thing. I mean, application can't be patented. If you're combining a couple of things or many things together in order to achieve any new output, then it can't be patented, because you need to show something which is not obvious, which is not very obvious. अगर मैं बोलूँ कि मैं यहाँ से एक गियर लगा के गियर का रिडक्शन कर रहा हूँ और मैं वहीं बोलूँ कि मैं दूसरा बड़ा गियर लगा के गियर का एम्पलीफिकेशन कर रहा हूँ, so this is very obvious. Deploying a small gear and gear will do something which is very obvious, right? So you need to do something which is not obvious. तो वही चीज़ हमारे केस में भी हुई थी कि बॉट में हमने हर एक चीज़ लगाया था, सब कुछ लगा दिया था, बहुत बढ़िया था. सो नॉवेल्टी वॉज देयर, बट नॉन ऑब्वियस क्राइटेरिया को हम क्वालिफाई नहीं कर पाए थे, बिकॉज दोज थिंग्स वर ऑब्वियस कि अगर हमने ये चीज़ें लगाई हैं तो ऐसा होगा. दोज थिंग्स वर ऑब्वियस, राइट?
Okay, sir. Thank
And
you.
for any detailed discussion, you can take my number and उसके बारे में हम बहुत डिटेल में डिस्कशन कर सकते हैं. If you have any query regarding this or any particular product you are talking about जिसके बारे में आप सोच रहे हैं पेटेंट करने के लिए, so how you can go for the patent and what is your patentable state at this time, इसके बारे में हम लोग बात कर सकते हैं. If you need to put some further technology, some further technicality into this, we can discuss about this.
Sir, how can I contact you? Can you share any kind of contact?
संदीप जी हैं, संदीप जी के थ्रू आप कांटेक्ट कर सकते हैं,
So,
राइट? उनके पास नंबर है.
there is another question, sir. If a person who is researching under government organization or in a private company and made a discovery or invented a new product, in that condition, can the researcher go for the patent?
Of course, sir. There is no any hindrance or boundaries for those people who are working with the government. Of course, they can go.
I think this question is related to whether patent would lie, means ownership of patent would be with that organization or with that individual.
Depends, sir.
Yes.
Couple of things are there. One is applicant, and another is inventor. So in most of the cases, if the financial responsibility is taken by the organization, then there is a foundation to make them as applicant. And inventor में तो आपका ही नाम रहेगा. But if you don't want to give anything to the organization, you just you should bear all the expenses included, right?
So in case applicant is different and inventor is different, who will claim the royalty? Means who will get the royalties during commercialization? That is the question.
Unfortunately, applicant.
Okay, so it will go with the applicant, definitely.
Right.
So that is the obvious part. I think that was the question asked by Prashant Kushwaha. So and we must be aware for that. Recently, one first year student, means now he must be maybe in second year. So he asked me regarding this, that I want to take this help from institute, and then I highlighted this point, and then
I intentionally didn't mention this part.
Yes.
Because ये थोड़ा सा डेटर वाला पार्ट हो जाता है.
Yes.
तो मेरे दिमाग में था एक बार इसके बारे में बात करते हैं, एप्लीकेंट और इन्वेंटर के बारे में, बट इंटेंशनली मैंने बात नहीं की इसके बारे में.
हाँ, and फिर he chose to file patent by himself, and his patent application is in process of being filed. So, and I wanted to highlight this part also because it is not that if you are in first year or second year and final year of BTech and you cannot go for filing patent. There are people, they are filing patent.
I think couple of conditions are there. See,
Yes.
Before filing any patent, we perfectly know whether we are going to produce any product based on this or not, because most of the patents are filed only for having your name connected with the patent, right? So बहुत कम ऐसा होता है कि हम किसी प्रोडक्ट को बनाने के लिए पेटेंट फाइल करते हो या प्रोडक्ट बन गया होता फाइल करते हो. So in that case, when you are sure that you are not going to produce anything based on this technology, so you should take advantage of the institute where you are connected with, right? So उनको फाइनेंशियली आप बेयर करने दो, 50-60 हज़ार रुपये आप क्यों बेयर करोगे? कोई फर्क नहीं पड़ता कि एप्लीकेंट आप हो या एप्लीकेंट कॉलेज है, until you are producing some product based on
Yes.
your patented idea.
Yes,
right?
if you are not this commercial utilization, if you are not looking for कि इसे commercially utilize नहीं किया जाएगा, then definitely one can go for
Sure,
Yes.
sure, sure, sure. Sure.
So I think now we should stop at this point, and if anyone is interested, I have contact number of Mr. Mahib, and you can contact me at our institute, and then he is very helpful person, and he has means hands-on experience for uh, this in this field of patent filing. So he is one of the most suitable person for this. So
Thank you, sir.
at this point, just I would like to means end this session with the where I would like once again thank that you have given your valuable time and came here for this workshop online. And sir Mahib ji, we would also earlier I said we would like to host you again, and again for not only online events, for physical events also. So thank you very much.
Certainly, sir, certainly. I would love to come over there for a physical interaction. So I'm really thankful to all of you, especially Dr. Pushkar and Mr. Sandeep,